Good morning, Rayfield. It is a thankful, thoughtful Thursday, and today we're going to study HIPAA.
Welcome to the Agency for Persons with Disabilities Provider Training on the Health Insurance Portability and Accountability Act of 1996, or HIPAA, as it is more commonly known. The major purpose of HIPAA is to define and limit the circumstances in which an individual's health information, called Protected Health Information, or PHI, may be used or disclosed. This is intended to protect the privacy and integrity of people's health information, while allowing the flow of health information needed to provide and promote high-quality health care. It is also intended to combat waste, fraud, and abuse in healthcare operations. Progress through the course. The screen highlights where you are located in the presentation. You will be able to go back to an area, but you will not be able to advance the presentation forward. On the lower left side of the screen are the controls for playing and pausing the presentation, back button, adjusting the volume level, displaying closed captioning, and exiting the presentation. Interactive quiz questions appear throughout the presentation. You must answer the questions correctly to complete the module. Throughout this training, you can pause and resume playing at any point by using the controls at the bottom of your screen. Click the forward button to continue playing the presentation. This course is approximately 22 minutes in length. You are required to watch the course in its entirety and pass the quiz questions to receive credit. The learner guide that accompanies this course is located under the Resources tab of the Train Florida HIPAA Basics course page. Press the forward arrow to begin the course. This training is intended to provide you with a general understanding of what is required by HIPAA, as well as what you can do to meet those requirements. As an APD provider, you are responsible for protecting clients' privacy. Failure to comply could result in stiff penalties against you and the agency, both civil and criminal. HIPAA consists of three major parts: administrative requirements, privacy, and security. This training will focus on privacy and security. Privacy refers to the protection of an individual's healthcare data. It defines how client information may be used and disclosed, gives clients privacy rights and greater control over their own health information, and outlines ways to safeguard protected health information. The privacy rule applies to PHI in any format, whether electronic, written, or oral. Compliance with the privacy rule was required as of April 14, 2003. Security refers to how electronic protected health information, or ePHI, is stored and accessed. It includes standards relating to safeguarding ePHI, such as password protection, encryption, and physical safeguards meant to prevent unauthorized access to clients' ePHI. The Privacy and Security Rules were amended to include the Genetic Information Non-Discrimination Act, better known as GINA. That was signed into law May 21, 2008. GINA prohibits discrimination in health coverage and employment based on genetic information and clarifies that genetic information is a type of protected health information. The rules were also amended to include the Health Information Technology for Economic and Clinical Health Act, or HITECH, which is part of the American Recovery and Reinvestment Act of 2009. HITECH clarifies that not only covered entities, such as healthcare providers and health insurance plans, but their business associates, such as entities performing data analysis or billing activities, are subject to HIPAA. HITECH also gives clients the right to get a report on who has electronically accessed their protected health information. Before proceeding with the requirements under HIPAA, we will define some terms that will appear throughout this training. So, what is protected health information? By definition, PHI is individually identifiable health information that is transmitted or maintained in any other form or medium relating to the past, present, or future physical or mental health or condition of an individual. Provision of health care to an individual. For the past, present, or future payment for the provision of health care to an individual. The term individually identifiable health information means information that is a subset of health information, including demographic information and other personal information, which either identifies the individual or can reasonably be used to identify an individual with reference to other publicly available information. For example, a client's name, social security number, Medicaid number, date of birth, telephone number, address, and biometric identifiers, such as fingerprints and voice prints, can be used to identify that person. If this information is made available to a person unauthorized to receive it, and in the context of health-related data, that is, any information relating to the past, present, or future physical or mental health or condition of an individual, including payment for healthcare operations, it could constitute a breach of PHI. A breach is defined as an impermissible use or disclosure under the HIPAA privacy rule that compromises the security or privacy of the PHI. All breaches must be reported to the Office of Civil Rights as well as the individual whose PHI was compromised. Certain breaches must also be reported to the Florida Office of the Attorney General and/or news media outlets. The HIPAA security rule is intended to minimize the occurrence of breaches and security incidents. An incident means there was attempted or successful unauthorized access, use, disclosure, modification, or destruction of information, or interference with information system operations. An incident is presumed to be a breach unless the covered entity can demonstrate that there is a low probability that PHI was compromised. Depending on the violation or violations, non-compliance with HIPAA can result in serious penalties, including civil penalties of up to $1,500,000 or $50,000 per violation, and criminal penalties, including imprisonment for up 1 year for knowingly obtaining and wrongfully sharing information, up to 5 years for obtaining and disclosing PHI through false pretenses, and up to the 10 years for obtaining and disclosing for commercial advantage, personal gain, or malicious harm. How does this affect you as a provider of APD clients? To fulfill APD's mission, you are responsible for providing services to our clients, some of which are health-related. HIPAA allows you to use or disclose PHI, as long as it relates to healthcare treatment, payment, or operations, known collectively as TPO. Treatment means providing healthcare and related services to clients. Payment refers to billing activities such as claims management and calculating insurance benefits. Operations refer to normal business activities such as reporting, quality improvement, case management, care coordination, training, auditing, data collection, and eligibility checks. It is important to note that anyone who does not have a TPO relationship with an individual is not authorized to access, use, or disclose that individual's PHI without written authorization. If anyone asks you to release protected information outside of routine TPO, you are required to get written authorization. Written authorizations should be in plain language and must include description of the disclosed or released information, the persons authorized to disclose and receive information, and an expiration date. A statement of the individual's right to revoke the authorization should also be included. The written authorization must be signed and dated by that individual or, if applicable, his or her legal representative, such as a legal guardian or healthcare proxy. You should only share the minimum necessary PHI to get the job done. For example, if you are billing Medicaid for a customer's health assessment, you don't need the customer's full medical record or the assessment results. You just need enough information to process the payment. Most requests for PHI require some form of written authorization, but not all. Written authorization is not required for the following purposes. In an emergency situation, if the client is unable to tell us his or her preference and disclosure is in the best interest of the client, such as to provide appropriate medical care. In any situation where PHI is needed to lessen a serious and imminent threat to a person's health or safety. Reporting suspected abuse, neglect, or domestic violence, and preventing or reducing threats to a person's health or safety. Sharing information with other state or federal agencies. For example, the U.S. Department of Health and Human Services, Federal Emergency Management Agency, the Centers for Disease Control, the Florida Agency for Healthcare Administration, the Florida Department of Children and Families, the Florida Department of Health, and other similar agencies, conducting research that benefits persons with developmental disabilities and or the Medicaid program, disclosing information for vital statistics, or with an organ procurement organization, coroner, medical examiner, or funeral director, disclosing information for workers' compensation claims, law enforcement purposes, and functions such as military, national security, and presidential protection services, and responding to a court order, including a warrant, administrative order, or a subpoena. You should always verify an unknown person's identity before providing PHI. Do not assume the person requesting access to PHI is who they claim to be. For example, if you receive an unsolicited request from a person claiming to be a detective with the police department, You should first call the published number for the police department to verify the name of the investigating officer and his or her phone number. Once you have verified that the requester is legitimate, you can call the phone number to provide the requested information. HIPAA requires covered entities like the agency and healthcare providers use reasonable safeguards when handling PHI. In addition to computer security, which we will discuss later in this training, reasonable safeguards include practices intended to reduce the risk to PHI. For example, when discussing PHI, have the conversation privately, behind closed doors, to minimize unintended listeners. Avoid using the client's name and discussing PHI in hallways, elevators, waiting rooms, break rooms, and other such places. Speak quietly, as you never know who may overhear your conversation. It is possible that the client you are discussing could be known to someone nearby, such as a relative, friend, associate, or neighbor. When conducting a face-to-face interview, do not leave PHI with anyone who is not authorized to receive it. Do not leave client records or other private information unattended, even if you trust those around you. When delivering or transporting PHI, first be sure that you have obtained authorization from a supervisor to transport client records between departments or off-site. Once authorized to do so, carry them close to your person. Carry them in a facility-designated bag, box, or container, if available. And ensure that no names are visible and no records are left unattended at any time. If transporting PHI off-site, place the documents in a locked briefcase, a closed container, or a sealed envelope and place that in the trunk of your vehicle or on the floor behind the front seat of your vehicle. If you must leave the PHI unattended, lock the vehicle. If transporting PHI in electronic form, it must be encrypted. There are no exceptions. This includes USB drives, CDs, DVDs, computers, or any other form of electronic media. If you are attempting to deliver documents containing PHI and the intended recipient is unavailable, do not leave the documents unattended. You can leave a business card with your contact information, if appropriate, but do not disclose any PHI. If you handle documents containing PHI, you should turn the paper over or cover the PHI when you leave your desk or cubicle so others cannot readily see it. Closing your office door is another option. Turn over or cover the PHI when a coworker approaches you to discuss something other than that specific PHI. Don't leave documents containing PHI unattended in fax machines, printers, or copiers. Check fax machines frequently to ensure that documents are not left on the machine. When you need to dispose of documents with PHI, do not include them with regular trash. Shred or place all confidential paper in designated confidential paper bins for appropriate disposal off-site. If you need to dispose of electronic media such as floppy disks, CDs, or USB drives, ask your supervisor about how to properly dispose of these items. Another key element to the protection of our clients' PHI is to keep the physical building or facility where you work secure. Here are a few tips that will help protect client PHI at work. Wear your ID badge at all times. It helps to identify you as an employee or provider. When entering your work facility, be sure others who are entering with you are authorized employees with ID badges. Keep hallway doors that lead to client care areas closed. And require vendors and contracted individuals to sign in and obtain approval when visiting a restricted area. The privacy rule permits certain incidental or inadvertent uses and disclosures of PHI. Under certain conditions, if an employee unintentionally and in good faith acquires, accesses, or uses PHI within the scope of his or her job duties and the accidental disclosure does not result in further unauthorized acquisition, access, or use of PHI, this is not considered a breach. Similarly, if an employee or provider inadvertently discloses PHI to an unauthorized person within the same agency and the accidental disclosure does not result in further unauthorized disclosure of PHI, this is not considered a breach. For example, if you intend to send an email with client PHI to your boss but accidentally send it to a coworker, you should notify the unintended recipient of the mistake and ask him or her to delete the email. Assuming your coworker complies, or at least does not share the email, this is not considered a breach for both you and your coworker. One key element of protecting our clients' PHI lies in maintaining the security of our internal systems that house and transmit electronic PHI. The HIPAA security rule outlines some standard security measures we can use to protect the confidential and private information maintained within the provider's computer systems. These measures include requiring all users to use individualized and unique usernames and passwords to access each system and application. This controls what users are able to access and helps identify what information has been accessed. When using a computer, always log off, or use the option to lock your computer screen that prevents other users from gaining access to your applications. In addition, do not share your password with anyone. Sharing passwords defeats the purpose of creating a password, and can result in a HIPAA breach in which you are liable. Breaches can be caused by providers or employees not logging off from their workstations, sharing passwords, discussing patient information in public, or inappropriately disposing of PHI. In the event that a HIPAA violation occurs that could potentially compromise the security or privacy of client PHI, the covered entity is required to notify the affected client as well as, depending on the extent of the breach, the Secretary of the Department of Health and Human Services, major news media outlets, and, pursuant to Florida privacy laws, the Department of Legal Affairs and credit reporting agencies. Breaches affecting 500 or more people must be reported to all of those people and entities. Remember, not all incidents are necessarily breaches, so not all violations need to be reported to those people and entities. However, if you know or suspect that a violation of HIPAA has occurred, you are required to immediately notify the individual designated by your organization to handle these matters as well as your immediate supervisor for appropriate follow-up. You and the organization you are a part of are responsible for the incident may be required to take additional action to mitigate the risk posed by the incident. If notifications are necessary, the covered entity must contact the affected individual or next of kin as soon as possible but no later than 60 days after the discovery of the breach. If the covered entity is unable to locate the affected client, the covered entity must post a generalized notice pursuant to HIPAA regulation. The notification must be easy to read and include a description of what happened and when, what information was specifically involved, steps the client can take to protect himself or herself, and what the agency is doing to investigate the breach, protect the affected client, and prevent future breaches. The client will also be given a toll-free phone number, email address, website, and/or postal address to contact the covered entity for more information. In addition to the requirements discussed so far, HIPAA also establishes various rights for all persons who have a treatment, payment, or operations relationship with a covered entity. These rights are explained in the Agency for Persons with Disabilities Notice of Privacy Practices. All clients and, if applicable, their legal representatives will be given the Notice of Privacy Practices at the time of initial face-to-face contact with the Agency for Persons with Disabilities. It is also available from the agency's website, and is posted in all APD clients servicing buildings. This notice delineates various client rights, which include the rights to the following. Get a copy of their health information. Get a copy of the Notice of Privacy Practices. Ask the agency to correct or change health information if it is believed to be incorrect or incomplete. Request confidential or alternative communications, such as requesting voicemail be left at their home rather than work phone number. Ask the agency to limit what information is used or shared, which the agency need not agree to if it will affect their care. Get a list of those with whom the agency has shared the client's health information, which is known as an accounting of disclosures. Choose someone to act on the client's behalf, such as a legal guardian or healthcare proxy. Receive notification of a breach, and file a complaint. If you are aware or suspicious of an accidental or intentional HIPAA violation, it is your responsibility to report the violation. The agency or your employer may not intimidate, threaten, coerce, discriminate against, or take other retaliatory action against anyone who in good faith reports a violation. These violations should be reported to the individual designated by your organization to handle these matters as well as your immediate supervisor as soon as possible. It is important to report HIPAA violations for many reasons. Alleged violations should be investigated, evaluated, and documented so that violations can be prevented from happening again. Penalties can be kept to a minimum and your personal risk is minimized. Remember, there are stiff penalties for failure to comply with the law. You may be asked by a client to assist with filing a complaint. If so, you should direct them to either the individual designated by your organization to handle these matters, or the U.S. Department of Health and Human Services, Office of Civil Rights,